only $25 at the door? Awesome! How do I sign up? Oh, easy. Go to HallieElise.com. Nice. $5 off online? Oh, I've got to call the girls and tell them about the Psychic Gallery on the first Monday of the month. Great time. 7:30 p.m. Perfect. Have to remember HallieElise.com for the Psychic Gallery.
Tune in to a special edition of Talk Legal with Jeff Van Treese, where Jeff will be interviewing the prosecutor that put Charles Manson behind bars, Vincent Bugliosi, about his book, The Prosecution of George W. Bush for Murder. That's Tuesday night at 6 on WNN 1470.
Talk 1470, WWNN Pompano Beach, Boca Raton, Miami, Fort Lauderdale.
Times are tough, and right now those in the commercial world know that being heard via advertisements is the name of the game. AmpSquare.tv understands how important advertisement is and is proud to express that it's truly the only plugged-in internet television production company on the market. Amp2.tv live streams all their shows across all the major selling markets in the U.S. and abroad. Call them at 866-224-5422. The AmpSquare.tv library allows productions to be seen over and over again, making commercial platforms more usable. Call 866-224-5422. Toll free 866-224-5422. Amp2.tv. The first and only internet television network that's truly plugged in. 866-224-5422. That's AMP2.TV. CPA for the People provides CPA services and business consulting for innovative creators. Collaborative, personal, affordable. We specialize in tax consulting, business consulting, financial statement compilation, and personal finance. For more information, please go to www.cpaforthepeople.com or call at area code 630-244-7893. Youthful Savings creates and delivers innovative financial education products through a virtuous approach in order to disrupt the cycle of poverty. We provide affordable college planning solutions through our Financial Freedom web application and program, youth financial education and entrepreneurship training through our My Own Business Challenge curriculum and program, and group youth programs that teach entrepreneurship and financial education. 10 cents of every dollar earned is reinvested into the communities saved through the Youth College Scholarships. For more information, please go to www.youthfulsavings.com. Email at info@youthfulsavings.com or call 646-504-7164. The opinions expressed on the following sponsored program are strictly those of the host, guests, and callers, and not necessarily those of this station, its staff, management, or sponsors. Welcome to We Are the People with Tracy Marks and Jorge Estamba, who ask you to know what's happening with your student loan. Tracy and Jorge keep a deep look at student loans in this country and the industries that surround it. Every week, We Are the People will bring you new insight into the corporate welfare industry, such as bailouts, and they connect with student loans. The show will highlight on your constitutional rights and how the current system is built to infringe upon them. Join the conversation by visiting our website chat room at wearethepeople.tv. Or call the show at 888-565-1470 and let us hear from you. And now, let's tune in to Tracy and Jorge for this week's discussion.
Good evening and welcome. This is We Are the People, Students for Liberty. My name is Jeff Van Treese. I'm filling in for Tracy Marks, the usual host this week. I host a show on Tuesday nights at 6 o'clock, Talk Legal with Jeff Van Treese, where we discuss a variety of legal topics. My guest in studio this evening is Neil Codsey. Neil just launched his first episode of his show this evening, which airs Monday nights at 6 o'clock. It's called Attorney Confidential with Gus and Neil. And they just wrapped up their first show, and definitely excited for that launch. This evening, we're going to be discussing some legal aspects of student loan debt. and trying to look at things from a little bit of a different angle. So, Neil, thank you, and welcome to Students for Liberty.
Well, thanks for having me. It's just a half hour after my first show, and it's good to be back on.
So I just want to make sure I say that you should visit the website, wearethepeople.tv. You can see all archived episodes of this show with Tracy and Jorge, who are normally here, but they had a scheduling conflict, so I was very happy for the opportunity to fill in. I'd also like to mention that tomorrow night, 6 o'clock, my show, we're going to be having a special guest on, Vincent Bugliosi. He was the prosecutor that put Charles Manson behind bars, and we're going to be discussing his controversial book, The Prosecution of George W. Bush for Murder. He also has a DVD with a slightly different title called The Prosecution of an American President, where he talks about prosecuting Bush for the Iraq War. So tune in tomorrow night at 6 o'clock for that. Very excited about having Vince come on the show. So getting into some news about student loans, I recently read an article that there are 22 states, Florida's one of them, that can revoke professional licenses if you have debt in general, student loans in particular. And Neil is an employment lawyer. You've done a lot of litigation with labor issues. And I'm wondering what your thoughts are on that. The whole concept of not letting someone get licensed for a profession when they've received education for that profession, but now they can't practice that profession because they have debt.
Well, it is the classic example of penny wise and pound foolish. You could see a rationale in a vacuum as to why you'd want to penalize someone for defaulting on any loan, or a student loan for that matter. But if the penalty for defaulting on a student loan is going to be to take their livelihood away from them, then you have penalized both the lender and the student who's not paying back their loan, because you've penalized them in a way that they can't pay it back. It seems like that is absolute penny wise and pound foolish.
Yeah, it sort of goes back to, when we created the Constitution way back in 1776 and the Bill of Rights in 1791, we abolished debtor's prison. And,
right.
You can't go to jail for owing money. There's some circumstances where you can go to jail for contempt of court, and, for example, refusing to pay child support. If you have the ability to pay it and you don't pay it, you can go to jail. But that's for contempt of court. It's not simply for owing a debt that you can't afford to pay. And in a situation like this, it's a punitive measure. It's punishing somebody for owing money. And that's something that really our founding fathers were against. So I think it sort of goes against the spirit of the Constitution as well.
Well, I would agree. I mean, I think that you make a classic point in that the debtors' prisons were abolished because people were penalized, whether they could pay the debt or not. And there was no one looking back at why they weren't paying the debt. When we talk about failure to pay back a loan, we have so many mechanisms in this country now for garnishing wages or doing other things that can make a person pay back a loan if they're choosing not to do it when they're able to do it. But when you talk about taking someone's license away from them, you're taking away the very means they have for repaying the loan. It makes zero sense.
And in some ways, they might be worse off than if they didn't have their education at all, because if you have an advanced degree and you have a professional license associated with that, then you might be considered overqualified for other jobs. So you might be just in the worst position possible. And like you said, the whole point is to have somebody be able to repay the debt. If they can't work, they can't practice their livelihood, then it's just going to be just going to spiral out of control. And this is very concerning. It also goes back to the whole concept of what contract is based on. Contract, unlike tort. A tort is a wrong, something like somebody's negligent or somebody does an intentional act and hurts someone. A contract is just an obligation that somebody agrees to, either expressly or an implied agreement. And the whole purpose of the law of contracts is to reimburse the party that did not breach, the non-breaching party, for put them back in the position they would have occupied had the contract been fulfilled. It's not meant to punish the person for breaching the contract. That's something that we've always learned. In fact, this becomes an issue with liquidated damage clauses, where those are provisions in the contract that say what the damages are going to be if one party breaches the contract. And it cannot be punitive. If the contract is written in a way that liquidated damages are punitive or they punish somebody for breaching, then that's invalid as a matter of public policy. So I mean, this just goes contrary to so much that our laws and the foundation of our country is built on, going all the way back to abolishing debtors' prison.
Right, and the one thing is a contract by its very nature is going to anticipate what you do when someone breaches it. So when you get a student loan or any other type of loan for that matter, you fill out a lot of paperwork, which encompass the very contract that you're filling out. And those contracts, it's been a while. I got my student loans for law school in 1990. Well, actually, I got the loans, I guess, 1987 is when I applied for my first law school loan. I graduated in 91. I remember filling out detailed paperwork, which would have those enforcement mechanisms in it if I hadn't paid back. I finally, embarrassingly enough, 91 was when I graduated law school and I paid the loans back. I believe I got the 20-year plan. So hasn't been that long ago since those were paid back.
Yeah, and you recently were able, and congratulations, of course.
Thank you. And that was back in the day when I went to Wake Forest. It was only $15,000 a year. I hear now a lot of those schools are $30,000 and $40,000 a year.
Yeah, they've doubled and tripled,
Yeah.
and it's really gone out of control. The other thing that I'd like to talk about is the whole concept of what we call character and fitness associated with some of these licensing, with these professional licenses, because you might have a situation like with telemarketers where you're going to be getting somebody's financial information, their bank account information, their credit card information. And if that person has a criminal background that would make them untrustworthy, then, for instance, the Department of Business Regulation or similar department, depending on which state, can say that your license to get this information will be revoked. But it's a similar argument being made here that if you owe student loan debt or you owe any sort of debt and you haven't repaid it, that there's something wrong with you or you're not fit to practice a particular profession. And I think that's just a very weak argument, just all around.
I agree. I mean, in the law, one of the things we're always fighting is the one-size-fits-all approach. And typically what we find is it's always the government that's taking that approach.
Yeah.
And what you have are circumstances where people have every intent of paying the loan back. But for whatever reason, they have medical issues come up one year where they're paying exorbitant medical expenses, or they have a family matter. They need to help their brother or sister or parents or children with an expense that makes it difficult for them to pay that loan back. So there are circumstances where you can't apply the one-size-fits-all. I'm sure there are people that aren't paying back because they don't want to or they want to try to avoid it. But my guess is that's the minority of people that are doing that. So you can't penalize everybody because of the few bad apples out there that aren't doing what they contracted to do.
And of course, if somebody really is able to pay back their debt, the consequence of not doing so, as far as damaging their credit and everything else, is probably going to be deterrence enough. You don't have to take their license away.
Right, and that's true too. I mean, there are a lot of penalties out there. Plus, most of these contracts, you and I talked about this before the show, most of these contracts have an attorney's fees provision in them.
And that's the other thing I'd like to turn our attention to, and we'll probably have to go after the break and continue our discussion. But attorney's fees is an interesting concept. They're usually created by contractual provisions. In other words, there's something in the contract that says that the losing party essentially has to pay the winning party's attorney's fees if there's a dispute that arises. That's something that then, after there's a judgment in favor of whoever wins the case, in this case the plaintiff's going to be the Department of Education, or if it's a private lender, it'll be that private lender like Sally Mae or someone like that. After they obtain a judgment, which are usually default judgments because the defendant, the student loan debtor, is not going to be represented, they'll put in a motion for attorney's fees. After they get that judgment, then it'll go to a separate hearing with a judge, and at that point the judge will have to determine whether the fees are reasonable. I'm sure you've done a lot of contract disputes where you've had attorney's fees provision. If you default on a lawsuit, if you are served, you don't answer within the 20 days, and then you default, can you then contest the attorney's fees at that point?
Makes it a lot harder. If you default, then you've been found liable as a matter of law. It's the amount of damages are still in dispute.
So potentially you could dispute the reasonableness of the fees, but not the entitlement to the fees.
Correct.
So we're going to have to take a short break to hear from our sponsors, and then we'll be back. Please stay tuned.
CPA for the People provides CPA services and business consulting for innovative creators. Collaborative, personal, affordable. We specialize in tax consulting, business consulting, financial statement compilation, and personal finance. For more information, please go to www.cpaforthepeople.com or call at area code 630-244-7893. Youthful Savings creates and delivers innovative financial education products through a virtuous approach in order to disrupt the cycle of poverty. We provide affordable college planning solutions through our Financial Freedom web application and program, youth financial education and entrepreneurship training through our My Own Business Challenge curriculum and program, and group youth programs that teach entrepreneurship and financial education. 10 cents of every dollar earned is reinvested into the communities saved through the Youth College Scholarships. For more information, please go to www.youthfulsavings.com. Email at info@youthfulsavings.com or call 646-504-7164. You're listening to We Are the People with social justice advocates Tracy Marks and Jorge Estamba, exposing the faults in our current day society with industries that directly influence student loans. Join the conversation by calling into the studio at 888-565-1470 or join the chat room at wearethepeople.tv. Again, to call in, the number is 888-565-1470, and let us hear your voice. Now, back to our show.
Welcome back. This is Jeff Van Treese filling in for Tracy Marks for We Are the People, Students for Liberty. My guest this evening is Neil Kodsey. He is an attorney, and also he's the host of a show that just launched this evening, Attorney Confidential with Gus and Neil. So before the break, we were talking about attorney's fees and an award of attorney's fees, which is often, or in almost all cases, granted to the lender in a student loan judgment. After they take you to court and they get a judgment, they get awarded attorney's fees. And we were saying before that generally, if you default, in other words, you don't fight the lawsuit, you don't file an answer, and you default, then you have given up any right to dispute the entitlement to the attorney's fee. So you can't come in and say that you're not entitled, or rather the lender's not entitled to attorney's fees, but you might be able to dispute the reasonableness of the fees. That is, that you could argue that the attorney's fees are too high or not proportionate to the work done, that sort of thing. So if you were representing a borrower in this situation, let's say they had a defaulted judgment, and they come to you and they have attorney's fees that are through the roof. What are some of the issues that would come up?
That's a tough one. I mean, you would hope that they would come to you before the default.
Yes.
And if there's any advice I could give anyone out there who has been sued, whether it be for a student loan or anything, is don't wait to get an attorney. Because if you default, if you don't play by the rules, the repercussions could be astronomical and certainly exponential as to what you may end up paying. The money you save by not hiring an attorney immediately will come back to haunt you if you lose and have to pay things like attorney's fees to the prevailing party. What we can do is challenge the default to see if there is an excusable neglect to try to get the default vacated. That's tough. I've had a few instances where we've been able to do that, but that is a very difficult process. The next thing to do is to challenge the necessity of the fees, because how high should attorney's fees really be for the lender if they got a default? they got a default, they really didn't have to work very hard to get it. They didn't have to debate the other side. They didn't have to engage in complex motions practice. They got a default. So hopefully the fees won't be too high, but you have to be worried about debating that issue back and forth because you pretty much waived by defaulting your right to challenge the entitlement, as you said.
And another thing that's important about getting an attorney, and I've represented student loan debtors, and one of the things, especially for private loans, you hope that you don't have private student loan debt because you can't get on an income-based repayment plan or an income contingent plan. But you can negotiate oftentimes with the lenders, and the lenders do have some wiggle room to negotiate with you, and that's something that an attorney is generally going to do much better negotiating on your behalf than you could negotiate on behalf of yourself. The other thing with an attorney's fee hearing is that if you are representing the debtor or the defendant in this case, one of the positions that you could take is that there's no that the entitlement to fees might be limited only to that which is owed by the plaintiff. In other words, only that which the plaintiff has to actually pay their attorney.
Right.
Because in many instances, these collection cases are on a contingency fee basis. That is, that the plaintiff's attorney, the attorney representing the lender, only owes or is owed a percentage of the total recovered amount. And so, I would take the position. I actually have taken this position for it, unfortunately unsuccessfully, that the most that you're entitled to is that contingent fee. So if you get 1/3, then the most you could get in the form of an attorney's fee is 1/3. So 1 1/3 was the most that the total amount owed by the defendant could be. This often is not, however, how the plaintiff's attorneys will structure their requests for attorney's fees from the court. They'll ask for an hourly amount, even though their client, the lender, doesn't owe them any of that money. So that's another interesting way that it could go. The courts are not exactly clear on what you can do under these circumstances, but there is some language from the appellate courts that do say that the limit of an award of attorney's fees is only to reimburse the plaintiff for what's owed. So that's another interesting issue that could come up. With respect to wage garnishment, if you've had any experience with that, are there limits on what can be garnished?
Yeah, I had a little experience. It's been a while, but I believe each state's going to be a little bit different, and I'm not sure if there's federal law on point, but each state's going to have a percentage. When you lose a verdict or the other side's entitled to wage garnishment, you have to fill out a questionnaire which explains your assets, what your other debts are, what your expenses are, and the court's going to leave you with some money. They're not going to garnish your entire wages. So there's a formula that each state uses to determine what the maximum amount that can be garnished is. So if you make $500 a week, but that's $2,000 a month, but your mortgage is $1,000 a month, and you have certain expenses you need to eat, you're unlikely to have a court garnish more than a couple hundred a month because they're going to look at those other expenses. So there's a formula. I honestly don't recall what it is, but there's a formula that each state's going to use, statutory.
Or if you have what's called a head of household status, so you have dependents that are relying on you, then they're going to be a limit. That's a percentage of your total income that can be garnished.
Right. All those factors will come into play. But I do want to go back, Jeff, into one point you made about negotiating. The fact that you can negotiate on a loan payment also means that you're being contacted before they file a lawsuit. The lawsuit's not the beginning of the process. The beginning of the process, if you default on a loan, is the lender contacting you and trying to work it out, which is even a better time to get an attorney or someone else involved on your behalf before there ever is a lawsuit. Because just like with home mortgages, student loans, you can sometimes negotiate down a different rate. Just like with credit card debt. Credit card companies will negotiate out with you. There are companies that specialize in that. So it's important in the process to try to solve this problem, if there's a problem, before you ever get to a lawsuit. The lawsuit's the last stage of the process. Hopefully most people don't ever get there. They negotiate appropriately with the lender before we ever get to a lawsuit.
Of course, one of the major negotiating tools used on behalf of the debtor is that you say, well, if you don't accept our offer, then my client is just going to file bankruptcy and
Right.
you'll get nothing anyway. With student loans, on the other hand, you don't get to do that because they cannot be discharged in bankruptcy under most circumstances. I was actually on this show with Tracy a number of months ago. We were talking about there is a test in bankruptcy that if you can show what's called a certainty of hopelessness, that you will ever be able to repay the debt, then you can get an undue hardship exception to the non-dischargeability condition that normally would accompany a student loan, and you can get it discharged. But that is a very difficult burden to overcome. It's not freely granted, and it's not going to probably have any leverage whatsoever in a negotiating situation. But you can negotiate because the debt collectors, they get a percentage, and they'd rather you negotiate oftentimes a lower amount than just default and never pay anything. Of course, if you're in a position where you can't make your payments, you can't make, if you're on a federal student loan, you're on an income-based plan or something like that, that might be a better option. But if it's a private student loan, you don't get to have an income-based plan where you just have 10% of your income and it's capped, and then anything left over after 25 years is forgiven. You don't have that option available. So you really just have to have a good old-fashioned negotiation, and that's something that you're often much better with if you have an attorney.
Absolutely. Because you need someone by your side on that negotiation process, because the amount you'll save, and it's the same thing going through bankruptcy or going through any other negotiation.
Right. The other thing that has come up, and I don't think the law is very clear on this, surprisingly, and probably because for the reasons we said earlier, most student loan debtors are not represented. So there's not a whole, it's not like there's a huge amount of lawsuits here that have made it up to the appellate courts in the same sense that we have, lots and lots of personal injury cases where, every aspect of personal injury has been dealt with by the appellate courts. But with the issue of sovereign immunity, that is, the government, or in many circumstances an agent of the government, whether it's federal government or whether it's state government, has immunity from suit.
Right.
So
the king can do no wrong,
right.
is the doctrine.
The king can. We just have a couple minutes left, so I just want to touch on this real briefly. It's an issue that can come up with not just the Fair Debt Collection Act, but also Rule 11 motions, which is for a frivolous pleading. You might have a situation where the debt's been discharged, as happened with one of my clients. The debt had been discharged, and I couldn't go after the attorney for the Department of Education because they had immunity after they had filed pleadings that at that point were moot. So we have to wrap this up relatively quickly. Neil, if you could give out your contact information in the event that any of our listeners are in need of your services.
Absolutely. My website will have all my contact information. That's ndkodsilaw.com, ndcodsilaw.com.
And make sure to watch Neil's show Monday nights at 6 o'clock. Just to give my information out, my law firm's website is oltmanpatent.com. That's oltmanpatent.com. We practice intellectual property, and if you visit our website, you can view all archived episodes of my show, Talk Legal with Jeff Van Treese. We air Tuesday nights at 6 o'clock. And please tune in tomorrow at 6 o'clock, where my guest will be famed prosecutor Vincent Bugliosi, and we'll be discussing his book, The Prosecution of George W. Bush for Murder. Also his DVD, which I highly recommend, regardless of which side of this issue you're on, Prosecution of an American President, and you can look for that online. There's a great view for both attorneys and non-attorneys alike. So looks like we're running out of time. I'd like to give a very special thanks to my guest, Neil Kodsi. Thank you so much, and have a great evening.
You have been listening to We Are the People with social advocates Tracy Marks and Jorge Estamba, who every week bring to the light the needs and changes in our current system. Tune in every Monday night at 7 p.m. on wearethepeople.tv and participate in the conversation in the chat room or call 888-565 1470. Tune in next Monday for more information and facts. And Tracy and Jorge remind you to stay aware of your surroundings and challenges at all times.